seated, folks. We are here today for sentencing in the case State of Ohio versus Charles Reeder. Case number is 2019 CR 68. The court actually, Judge Martin had ordered a pre-sentence investigation, which I have read. I have also read the sentencing briefs by counsel representing the state of Ohio. In this case is Robert Smith from the Auditor's Office,
Correct.
Special Pike County Prosecutor, and Jim Smith, or Bolger, I'm all right. Mr. Bolger is here representing his client, James Bolger, representing Mr. Reeder. Now, I do want to compliment both the defense and the state. The sentencing briefs that they have prepared are extremely comprehensive, well thought out, well reasoned. So I have also taken into consideration the briefs provided by the parties. So at this time we'll proceed with sentencing. I would like to hear from the parties. I'll start first with the state of Ohio. Prosecutor Smith.
Yes, Your Honor. The defendant pled guilty to 2 counts of theft in office, felony of the 4th degree, and 2 counts of tampering with evidence, felony of the 3rd degree, 1 count of conflict of interest, a misdemeanor of the 1st degree. As part of the mandatory sentencing for theft in office, restitution is mandatory, as well as a lifetime disqualification from holding public office, public employment, or a position of trust in Ohio. Relative to restitution, the majority of the funds involved were removed from the 4 evidence bags cut open by defendant. $14,775 was removed prior to the defendant and his attorney turning those bags over to investigators for the Auditor State's Office. The different currency, new, in many cases uncirculated bills, were put into the currency bags, so that restitution would have been taken care of at that point. Additionally, there's a total of $4,850 outstanding, $3,500 from the purchase of the Nissan Versa, which was the profit made by the sheriff on that transaction, $350 owed to the people who purchased the Chevy Silverado, and $1,000, which the state says never made it into the evidence bag from the April Smith seizure. That total of $4,850, Mr. Bolger tendered cashier's checks to the state this morning for that total amount. So with that, restitution would have been paid.
So there's no outstanding restitution owed by Mr. Reeder in any of these, on any of these counts?
That's correct, Your Honor.
All right.
On the issue of merger, the state's position is that the 4 felony charges to which defendant pled guilty are not allied offenses of similar import. The defendant could have opened and removed the currency from those bags at the same time. That would have no impact upon whether these offenses that the defendant pled guilty to are offenses of dissimilar import. There are separate owners of each of the 4 evidence bags, of the currency in each of the 4 evidence bags. There were 4 separate Pike County arrests and seizures, which resulted in the 4 separate investigations and or official proceedings. Each evidence bag identified on it the lawful owner of the funds. As a result, each offense caused a separate and identifiable harm, and this court has the authority to convict and sentence the defendant for each of the counts. Relative to sentencing itself, the state would note that the defendant was an elected county sheriff who committed these crimes in his position as a county sheriff. He used his position to obtain control over the evidence bags and then used that control to remove the funds and use them for his own benefit. He then, as I said, later put money back replacing those funds when he was caught after the search warrant was conducted on December 13, 2018. I believe that in the one case which is especially instructive in this matter is State versus DeMaestri. The appeals court, in upholding the court's sentence, quoted from the trial court, who stated, "The court finds that this defendant has not been sentenced to prison for any previous offense but that community control sanctions or any lesser penalty than this court has imposed for any of the offenses would demean the seriousness of that offense and would not adequately protect the public from such offenders. Not simply this defendant, but every sheriff in Ohio and every prosecutor in Ohio who can be misled into thinking that public funds are slush funds for which there is no duty of accountability. And I think that holds true in this case. The state would recommend a prison sentence commensurate with those given to the, unfortunately, numerous other elected sheriffs in the state of Ohio who've been sentenced for felonies committed in the course of their duties as elected sheriffs. Thank you.
Thank you, Prosecutor Smith. I'll now hear from Attorney Bolger on behalf of the defendant.
Can I remove my mask?
Yes, sir.
It'll be easier to understand. Addressing first and briefly, the question of merger. We have two counts tampering with evidence that both alleged to have occurred on a single date. That was the date that Sheriff Reeder presented to investigators of the auditor's office the evidence envelopes, but also thumb drives that included videos of the counting of the monies. It was a single act of delivery. There were multiple envelopes. At the time of the delivery, it was clear that the envelopes had been opened at some point in time. It was also understood that this would constitute the substantial evidence that would eventually support these counts in the indictment. Sheriff Reeder voluntarily produced these items with that knowledge. We believe that with respect to the tampering with evidence charge, it's clear that there's a single act, a single animus, and there ought to be merger in that situation. With regard to the theft offenses, I think it's a bit less clear. However, it is a position of the defense that the Sheriff's Department was the lawful custodian of all of those funds and constitutes a single victim for the removal of the monies and the eventual replacement. I'll move on now.
All right, when you say the sentencing on the thefts are less clear, actually the revised code mandates theft in office. Cases do not merge.
I understand that, Your Honor.
Okay.
However, our position was that there was a single victim. I understand that the state has produced a documentation that Mr. Woodruff was granted an order that would require the return of the monies to him at some point in time.
All right, thank you.
We're dealing now with the purposes of sentencing, protection of the public, punishment and rehabilitation. In this particular case, the court's had an opportunity to review dozens of letters that have been given voluntarily in support of Sheriff Reeder. Just expressions of sincere appreciation for his efforts as sheriff, recognition of the personal cost that he has been exposed to in his attempts to discharge the duties of sheriff. We see repeated expressions by persons who seem to be a cross-section of this community. You can tell by the scrivening of the letters that we're dealing with a cross-section, that they felt safer than they had ever felt in their adult lives with Charles Reeder as sheriff of this county. They understood that he was a hands-on sheriff, that he was in fact 24/7. My own experience, approximately 40 years now, in this county and neighboring counties, is that when people get elected into the sheriff's office, they frequently simply disappear into an inner sanctum, not to be seen except occasionally. That was not the case with Sheriff Reeder. He was hands-on from the beginning of his tenure. He was active on the road. He was active at scenes of crimes. He was active with individuals who really had no necessarily call upon his duties, but he volunteered himself repeatedly to assist people when he saw there was a need. So when we talk about protecting the community, we're in a curious situation in this case because he is perceived by a substantial portion of the population in this county as having delivered protections that they had not received before. Many of them would, if they could, have him as their sheriff from this point forward. When we consider...
Some of the letters say that exact same thing, yes.
When we look to the purpose of deterrence, which is embedded, I think, in both the purpose to protect and also in the purpose to punish, we come across a situation where the individuals, the citizens of this county who are most directly affected by his criminal conduct, see apparently a deterrence that Mr. Reeder brought to his efforts as sheriff in this office. A deterrence of criminal activity in a county that is impoverished, a county that has been experiencing a major opiate crisis, a county that has an execution-style assassination of 8 individuals during his watch, with the addition of 7 other homicides. During his tenure, his budget was cut, increased the demands upon his own time, cost him his relationships with his own family members, and eventually put him in a position where his own mental health began to fail. He's now being treated for post-traumatic stress disorder, and I don't know that any of us can appreciate what he has been exposed to and what he has had to try to deal with on his own in this county. So I believe that all of these are considerations that ought to be brought into sentencing. He is not Gary DeMastri. He is not Sheriff Kelly of Athens County. He is not Sheriff Overmeyer. He has never lied under oath. He had no intention of lying under oath. He responded to instructions that I gave him concerning what he should do with the evidence that he had in his possession, and he carried through with it and delivered to the state the evidence that they now use to prosecute him successfully.
Wait a minute, that's after they searched the safe in the sheriff's office and none of the evidence bags were there.
That's correct.
And then I believe he talked to you and the auditor, and then they were recovered, or he offered them from his glove compartment or something in his in his Ford truck or something. Is that the way it went
produced
down?
an accordion file
Right.
in my office.
Right. But before you got it in your office, where was it?
That I will let former Sheriff
Okay.
Reeder speak to.
Okay.
So I believe that he is in a different position than the former sheriffs that have been alluded to in the state's presentation. He has flaws, there's no question about that. Some of them have been exacerbated by his own efforts as he drove himself in his office until the wheels came off. But I believe that you can gather from the correspondences that you've received and from persons that will be willing to speak to you now that he is basically a decent human being who has done what he could to help the citizens of this county, and most of them recognize that fact and appreciate that fact, and would wish that this court accept the recommendation of the pre-sentence investigation and that he be granted some form of community control. If the court would permit, we would have a couple of individuals speak right now.
Certainly. You may come forward.
Ms. Sheltman. This is Pamela Sheltman.
How do you spell your last name?
That's H-E-L-P as in Paul, M-A-N,
Sheltman?
Sheltman.
All right, thank you. All right, go ahead, whatever you'd like, if you want to remove your mask, go ahead. Oh, I've had my shot.
I never believed the sheriff was allowed to do this, but April 5th, my son passed away. Charlie took him out of there like he was going to the hospital. And on April 9th, my house burned down while I was at my memorial dinner for my son. Today we buried him. My house was on fire, and Charlie was the first one on scene. There's no greater man than Charlie Reeder. Thank you.
All right, okay, thank you.
And we'd also have Bethany speak as well. She's the daughter.
Go ahead, would you state your name for the record?
Bethany Shelton.
What would you like to say?
Charlie Reeder, he's an outstanding man. Back home, where I'm from, we don't have sheriffs like him. My house burnt down on my birthday almost 19 years ago. Nobody in my community would do anything like he did. He went out of his way. He took time out of his day to do what he needed to do, to be there for my family when I lost my brother-in-law. He didn't have to do that. So for me, if I could have him as a sheriff again, he'd be there. He'd be the one I want in office. He's outstanding, charismatic, amazing, respectful man. We all have faults. We all do dumb stuff. But he is a great guy. And for me, I respect him. He's done everything in his power to help my family out and go above and beyond. So he has my respect. And everybody else's respect behind him and my family.
All right, I appreciate your statement, thank you.
Your Honor, if the court would permit, we'd finally call Reverend Whitley.
Go ahead.
Good morning, Your Honor.
Would you state your name, full name for the record?
Reverend George Michael Whitley, pastor of McKibben Chapel Church.
Didn't you write you also wrote a
Yes,
letter,
ma'am.
did you not?
Yes, ma'am.
Right, go ahead.
Well, on behalf of Charlie and Pike County, I have found it an honor to know the man as someone I could call friend. I look here around me at the officers that are in this room, and I offer thanks to each one of them for their service, because, you know, when you put the badge on and you put the uniform on, automatically you make enemies. And around this little county that we have of Pike County, it's been a long time since crime had been on a downturn. As a minister and a resident, I live over on the west side, and we very seldom seen officers that, you know, unless there was a big problem. During his tenure, it was common to see Charlie or one of his deputies drive through at least once a day. And you know, that was something that had never happened before. And the man gained my respect. He went through one of the most horrendous crimes ever committed in our county to my memory. What he went through, I can't tell you, ma'am. The nights that he went sleepless, what his family went through, what it done to his health, what it done to his office. The punishment that could be ruled out here by the court, ma'am, Your Honor, I don't see how it could even weigh close to what his service to this county has put him through. But I believe in his heart, Charlie Reeder is a good man. Has Charlie made mistakes? Yes, ma'am, he probably has. But in the Bible it says, ye who are without sin cast the first stone. I couldn't throw many rocks at him because I've made mistakes too. But I myself, on behalf of the community that I serve, ask for leniency on behalf of Charlie. Ma'am, I don't know what all the law hands out. I really don't. I know less about this case probably than anyone in this courthouse today. But one fact I know, Charlie was a man you could count on when you needed him. And I would vote for him today, just as sure as I'm standing here, as God is my witness.
Yeah, that's what you
So,
said in
ma'am,
the letter.
I ask this on behalf of myself for leniency. Thank you very
All
much.
right, thank you, Reverend Whitman.
Thank you all for your service.
All right, anyone else wish to speak on the defendant's behalf?
No, Your Honor, but I believe Sheriff Reeder would like to allow Coop.
If you'll keep it brief, okay. But he's going to ask the court.
Hi, Your Honor. My name is Derek Myers. In 2018, I was a news reporter, and I was investigating a corrupt police chief in Southern Ohio. He had fabricated some charges against me to shut down my news reporting. I'd actually spent 35 days in jail. The police chief would go on to be indicted for what he had did to me, and we would file a civil lawsuit. And
What county was that in?
it was in PIKE County.
Oh, sorry.
And that November that year, I came to Sheriff Reeder and I told him I needed some redemption to help build my reputation back up because it had been completely tarnished. When you spend time in jail and you're falsely accused of crimes, your news reporting doesn't go very far.
I can imagine.
I spent a lot of time with the sheriff when he was sheriff, and he sort of redeemed me and allowed me to rebuild my reputation in the community. I think I saw a lot of times where he would work up until 2 or 3 o'clock in the morning, be right back at the office at 7 o'clock. During that time, I think it weighed heavily on his mental health. And by no means am I making excuses for his actions or his inactions, but I can't imagine what he had been going through during that time of handling the state's largest homicide investigation, as well as some other things that was going on in his personal life. So I imagine it made him make mistakes that he wished he wouldn't have made. But redemption and second chances is something that Charlie Reeder believes in, and he extended that to me. And it's changed my life. I've now gone on to work for other sheriffs and continually work for a current sheriff. But Sheriff Reeder gave me a second chance, and hopefully today you'll consider giving him community control so he can have a second chance as well. Thank you.
The court will now hear from Mr. Reeder.
Can he go to the podium, Your Honor?
Yes.
Your Honor, I stand here before you today to take accountability for my actions. As a sheriff of Ohio, I shed, excuse me, I shed bad light on the office of sheriff. I can only ask that my staff, their families, the community, and my family who is here today will forgive me for the undue stress I caused them. For this, I am terribly sorry. I stood in this court on September 24th and pled guilty to the charges against me, to accept responsibility for my conduct. That day, within minutes, everything that I'd worked for professionally and honorably for 25 years was stripped to me, with nobody to blame but myself. My staff and I had united with the community and had a partnership and trust. And they truly believed in us as a unit, as a whole. And I betrayed that trust. If I could go back and change it, I would a million times.
There's another box of Kleenex.
For this is not who I am. Never, ever did I imagine myself on the defense side of this courtroom that I've spent 25 years of my life in this county in law enforcement. As the sheriff, I gave my staff in this community all of me, every ounce of my being. You are aware, Your Honor, that this has affected my mental health as well as my physical well-being. There's nothing left for me to give or to take from me other than my freedom. I have and I now pray that the court will find mercy on me. And I beg the court, if they see fit, to grant me community control, even with the strictest sanctions that I have proven to this court in the past 2.5 years that I can abide by. I am a good person who made bad decisions and choices. I can continue to be a productive citizen in this county and be in the community with the love that I have for my family, my friends, and my neighbors. I'm asking all this so that I have the opportunity to watch my son graduate from high school and attend college this year. My daughter is getting married in October so that I can be there for her. And my wife, so that I can be a husband that I haven't been in 25 years due to my career. I've just not been there. Given the opportunity, I would be able to spend the time with my mother and my father and continue to be there for them when they need me. In the last years of their lives, as I've experienced this week with my dad, when 2 days ago I thought that I had lost him.
He's still at Riverside, isn't he?
Yes, ma'am.
He's not on a ventilator.
He is on, he's on 2 forms of ventilation without the actual
Well, that's
tube.
not what the nurse said, but okay. He's got some oxygen or breathing equipment, but it's not a ventilator. Okay.
I have no words for the shame that I have and that I feel and the regret that I have. Betraying and disappointing the trust that I had with my staff and the community. And causing damage to my family's good name. Again, I beg of you to impose a sentence of community service with the strictest sentencing and sanctions. Your Honor, please do not send me to prison. I have roamed, but I'm not ruined. I still have a lot of good left in me. And thank you for your time.
I have a couple of questions for you. The big question I have, and is on everyone's mind, I'm assuming, is why did you cut open these evidence envelopes and take the money out, and then in some cases you put it back, although you were caught because the envelopes had been unsealed and sealed again improperly, and the denominations did not match what was taken at the crime scene or from those individuals. I guess, why did you take the money?
I took the money, and mind you, this does not excuse it, but from drug dealers that took it from parents of very poor people in this county. That money, regardless of what the state and what the media has claimed in the past years of a gambling problem and that money being used for gambling, was used when there was a tree planted in the name of the Shelton boy. It's at the entrance of Western High School to the left as soon as you pull in. Nobody could pay for that tree. Nobody offered to pay for that tree. A drug dealer did. When schools had cheerleading or pee-wee that had car washes and such, I would have our cruisers taken down there. My men and women did not make good money, so some of them would give them $2, $5. I took money from that and I provided it to those people. Now, I replaced it in time. The money was not in the safe the day that they came and they did the search warrant in my office. 3 days prior to that, which the state has not included, I had knowledge from my secretary, Kelly Sanders, that the security company was coming into my office and that office was going to be open to anyone. I removed those monies from that safe and I put it in the back of the F-250 that I drove. Now, the day they did the search
I'm
warrant,
sorry, and it would be safer in the lockbox in your car than it would be in a safe?
In an
which
open
only- which
office?
only you have, and a few other people have the combination?
well, ma'am, no one should have had the combination but me. And it strikes me odd that Lieutenant Burchett at the time would make a statement to the state that he'd never seen the accordion file that I provided the state. I did so only on the direction of Chief Michael Spirits, who'd worked for the state at the time, who asked me if I had a comprehensive list of all monies that was in that safe, and I did not. Due to the prior sheriff, never, when there was an officer-involved shooting that involved his brother, that sheriff resigned, and I took over that office. When I swore him in as a special deputy, he left 2 black marks leaving that office. He handed me the keys, he never did an inventory of the safe, never provided any paperwork of what was in that safe, the money in that safe, or anything. I find it odd that in their search warrant, their confidential informant tells them everything to do with my office, where the safe is, that I have members of my staff telling them that they have never seen anything like that in my safe, which would only be suspect to the fact that they had gained entry into my office and into my safe to have that information to provide to the state. I did what Chief Spirits asked me to do. I organized and made a list of every envelope and every dollar that was in that safe, including the name of the defendant, the date that it was taken, and provided to the state at my attorney's office, to the point that I had to lend my knife to them to open these packages so that they could be counted. My attorney was called away for court, and I continued to stay in that office and assist the state in counting the money. To my knowledge, there was none of the envelopes that didn't contain the right denominations of money. Their discretion or their objective is that the money from a video that was counted appears to be different than money that was in the envelopes that they seen.
Well, from the video, from the PSI, the video shows on different dates, officers counting out money, in one instance yourself, coming to $7,000, for instance, and then turning it over, and there was like $600 short.
And ma'am, Your Honor, I advised my attorney I would take a stipulated polygraph on the $1,000 that I provided on that particular case, that the state now has a cashier's check for $1,000 for State versus Carter. At that scene on Rainbow Trail Road, I was with Lieutenant Burchett. It was videotaped. It was videotaped of Mr. Carter opening a locked door. There's a videotape that exists. Opening a locked door so we could prove that that door was locked and that Mr. Carter had a key. We entered that. It was being videotaped by Lieutenant Burchett. Mr. Carter pointed out where those funds were. They were in some sort of little container, if I remember correctly. They were pulled from that container and counted. They were taken to the back of that same F-250 and placed in the same lockbox in that F-250, where Mr. Carter got in the front passenger side of my truck with me. Lieutenant Burchett followed me in his vehicle directly to the office without stopping. We got to the office. I provided Lieutenant Burchett with the entirety of those funds. So where the $1,000 mistake comes in, I have no idea whether it was accounting error. I have no idea, but I would agree to a stipulated polygraph.
But you pled guilty.
I did, ma'am. Yes, Your Honor, and you're asking me and I'm giving you the explanation. And I have paid the restitution.
I understand you've given, yes, your attorney the
But
full
that particular case,
restitution that was owing in excess of $4,000.
$4,850, Your Honor.
That's been done today. All right, I want to go back to, all right, in the PSI, the pre-sentence investigation, it indicates what you're saying here as to why you claim you used the money for various charitable community things. And then, but the PSI officer notes that there's no documentation that you used it for those things.
Right, I did not document those
Okay,
things.
now, I want to ask you about this. All right, that's your statement, what you say you used the money for, and, okay, that's on record. But I do want to ask you some other things here. Okay, the majority of the acts in this indictment took place between June 2017 and July of 2008. June 2017 and September 2017. Okay. The state obviously alleges in their brief that, particularly since you do not have any documentation of that you use this quote for charitable purposes, they secured your bank records and credit card records and all of that, and it indicates, did you lose $3,000 gambling at the Scioto Downs Racino between June 2017 and September 2017?
Yes, not by myself. They have cards, and of course, again, Your Honor, I've pled guilty to this, but they have cards that you put in a machine. I can have a card in my name, and I can have a card in my name that my wife possesses. So I can be at one machine and she can be at the other. And the money that she spends and the money that I spend, they count on the same card and calculate the money as one. Now, the state has my financial records. They will see that when we are at those casinos, and I have not been to one since and will never be at one again, that the money was taking, that our debit card was put in a machine and the money was taken from our checking account.
Well, obviously, That doesn't answer the question, where did the money in the checking account come from, but no.
At that time, I was making the salary of the sheriff, and my wife was making approximately
I'm
$2,500
just asking the question here, that's all.
a pay.
Okay. Also, I want to ask you, in late June 2017, you took a trip to Reno, Nevada for the sheriff's conference, and then you withdrew $2,800 in an ATM. This is in addition to the expenses related to the trip for which you were not reimbursed until later. You see where the state believes that some of this is due to gambling. I mean, you're talking like over or almost $6,000 in a couple of months that you lost or expended on gambling.
And at that point, we were making almost $11,000 a month. And that
Okay.
again was from my checking account where it should show my direct deposits, my wife directs deposits, and that it came from our debit cards where I retrieved that money.
I don't doubt it came from your debit cards. The question is, where did the money come that went into your checking account? I guess that's up for a question.
That's where the media reported that I had marital problems because it came from our joint bank account. My wife made very good money at the time, and I took that money and I gambled.
Okay. All right. That's all the questions the court has.
Thank you, Your Honor.
Thank you. All right, I initially want to say, first of all, I have sentenced a number of public officials. Every case is different. No two set of facts are the same. In deciding what I believe is an appropriate sentence, the court has looked at the purposes and principles of sentencing. I've read over the briefs submitted by the attorneys. I've read over the pre-sentence investigation. You know what? I have one more question for you.
Yes, Your Honor.
Here it is. Okay. Now, the thrust of some of the letters, especially from Ms. Kraft, the licensed social worker.
Yes, ma'am.
Who didn't start to see until March 2019. It talks about the stress from all these cases, all these criminal cases, the rodent murders and whatever. Did you ever tell your counselors about stealing from the evidence envelopes?
Yes, we discussed that.
I'm sure there was a lot of stress and sleepless nights you had in terms of your post-traumatic stress syndrome or your anxiety caused by the fact that you opened up these envelopes and took money that didn't belong to you.
Yes, Your Honor. I was being treated since 2013 for those conditions, and it progressively got worse.
Well,
Now,
it got worse during the time period in which these offenses occurred, and in 2016, starting the investigation of rodent homicides. But I wanted to ask you that because from what I can tell, the social worker never mentioned anything in there as a stress factor. She just focused on your police work. And I would think, as I said, if you committed a
Your Honor,
series of thefts, wouldn't that cause stress? No, Mr. Boldrell, let him talk.
I didn't want him to interrupt you, Your Honor.
Oh,
Yeah,
okay, go
I
ahead.
apologize.
No, go ahead.
I believe in the last letter that she provided, she spoke of the court cases and the stress and things that I was encountering because of that as well. I'm unsure. I believe I provided that to my counsel.
Yes, but that's again, in terms of the stress over this case, which has caused, I'm sure, untold trauma for you and your family. It's always the unintended innocent victims, the families, that actually suffer the most from one's criminal misconduct. All right. All right, as I said, each case is different. I have sentenced a number of public officials across the state. So I'm trying to determine a commensurate sentence, which I am required to do under Ohio law. This court sentenced Patrick Kelly, the former Athens County Sheriff, to 7 years in prison. He was convicted of engaging in a pattern of corrupt activity, which is different. That count was here, but through a plea bargain, that was dismissed. He also pled guilty to 10 counts of theft in office, 1 count of tampering with evidence, and 1 count of tampering with records. I also sentenced the Sandusky County Sheriff, Kyle Overmeyer. I gave him a sentence of 4 years in prison. He was charged on 3 counts of theft in office, 3 counts of deception to obtain a dangerous drug, 2 counts of tampering with government records. The court sentenced him to 4 years in prison. I also sentenced Detective Sean O'Connell of the Sandusky Sheriff's Office. He was charged with 1 count of tampering with evidence, an F3, and the court imposed a 2-year prison sentence in that case. I also want to deal with the issue of merger before I go further here. Both sides have correctly cited to State versus Ruff, R-U-F-F, 143 Ohio State 3rd, 1114, 2015 Ohio 995 for the discussion of what can constitute a separate offense for sentencing purposes. We already know from the case law, State versus Krutz, I think it's K-R-U-T-Z, that theft in office charges do not merge as a matter of law. And the essence of the Ruff case is, of course, that the court must determine whether or not they're allied offenses of similar import, and the court must evaluate 3 separate factors: the conduct, the animus, the import. The import is generally interpreted as meaning effect. Syllabus 2, 2 or more offenses of dissimilar import exist within the meaning of Revised Code 2945-25B when the defendant's conduct constitutes offenses involving separate victims, or if the harm that results from each offense is separate and identifiable. A defendant whose conduct supports multiple offenses may be convicted of all offenses if any one of the following is true: the conduct constitutes offenses of dissimilar import, or the conduct shows that the offenses were committed separately, or the conduct shows the offenses were committed with a separate animus. I do not believe, the court does not believe there's any evidence in terms of when the envelopes were opened. If we want to believe Mr. Bolger's interpretation, they were all opened on the same day. That's probably not it, but I don't know. But that's not important to the merger analysis. Number 3 states, the conduct shows that the offenses were committed with a separate animus. They are each from separate victims, and this is evidenced in the indictment and the bill of information. So the court finds as a matter of law that none of these offenses merge pursuant to State versus Ruff or the Ohio Revised Code. These offenses occurred on different dates involving different victims. All right, now, what is the appropriate sentence? First, the court has to consider the purposes and principles of sentencing. I'm not required by law to go through every one of them, but I will go through the ones that the court has found important in this case. The purposes and principles of sentencing are delineated in Revised Code Section 292911A. Always consider the need for incapacitation, deterrence, rehabilitation, and restitution. Sentences should be commensurate with and not demeaning the seriousness of the offender's conduct and the impact on the victim, and consistent with sentences for similar crimes. Now, the seriousness and recidivism factors in this case under 2912B that are pertinent here is that there was serious economic harm, but more importantly, a consideration for the court is that the offender, Mr. Reeder, once the sheriff of this county, held a public office or position of trust related to the offense. The defendant's occupation, his elected office or profession obliged him to prevent this offense or to bring those committing it to justice. And also the other factor that is applicable here is that the offender's professional reputation or occupation, elected office or profession facilitated the offense or is likely to influence others. Now, the defense has brought forth some mitigating factors regarding stress of Mr. Reeder. I have a couple of observations about that, and I bring this up in reference to mitigation under 2912C. Substantial grounds exist to mitigate the offender's conduct even if they don't constitute a defense. Now, here's what I want to say. You've been in law enforcement for 24 years. Whether you are a sheriff, whether or not you're a sheriff's deputy, whether or not you're a prosecutor, whether or not you're a defense attorney, or whether or not you're a judge, you choose to be in this profession. We see horrible things, multiple deaths as you have, deaths of babies, torture of old people. This court personally has had to sentence a number of people to death, impose the death penalty. We all choose our profession, and we have to conduct ourselves with integrity so that everyone trusts us. Now, no person is good or bad, but you had an obligation, Mr. Reeder. The sheriff's office, like every other PERS entity, has a free counseling program. In other words, you could have sought free counseling at any point in time for your conduct. Now, from your general practitioner, doctor, your conduct has been escalating. You didn't take care of yourself. You had high blood pressure, a poor diet. You did your job, but you neglected your family. In this business, you have to be able to balance all of those things, and you have to take responsibility of the fact you didn't do it. You didn't reach out for help when you should have. And the other thing is, you mentioned the shame that it has brought on you, the shame that you have brought on to the entire law enforcement community. Every day we read a newspaper article, someone is critical of the law enforcement because they believe that law enforcement thinks they're above the law. You're neither above the law nor below the law. All right, I am going to pronounce sentence at this time in reference to count 2, the first count of theft in office under RC 292141A1, a felony of the 4th degree. The court is going to impose a prison sentence of 1 year. On count 3, which is also a theft in office count, same section as the court just read, that's also a felony of the 4th degree. The court's going to impose a 1 year prison sentence in that case as well. Tampering with evidence, count 4, 292112A2, I think. felony of the third degree, the court is going to sentence you to 2 years in prison on that count. Count 6, tampering with evidence, the court is going to also sentence you to 2 years on that tampering with evidence charge. And for the remaining count of conflict of interest in M1, the court is going to impose 6 months in the Summit County Jail. Now, the court believes that some punishment is appropriate for what you have done in terms of tarnishing the name, not just of yourself and your family, but of all law enforcement. And the deterrent effect is something I take very, very seriously. I also take into consideration what defense counsel and the witnesses have said also. As I said, no person is either all good or all bad. In reference to the charges, count 2 and count 3, theft in office, the court had handed out a 1-year prison sentence on those counts. Even though they don't merge as a matter of law, the court is going to order that those 1-year sentences run concurrently with one another. In reference to tampering with evidence, as contained in count 4 and tampering with evidence in count 6, the court is going to impose a 2-year sentence on each of those 2 counts to run concurrently with one another, but consecutively to the 1-year sentence for a total prison sentence of 3 years. Court's going, and on the misdemeanor conflict of interest, I'm going to impose a 6-month sentence in the Pike County Jail to run concurrently with that sentence. The court is going to impose up to 3 years of discretionary post-release control. Now, the court has given you consecutive sentences. I'm going to cite to Revised Code Section 292914 C4. Multiple prison terms are imposed on an offender for convictions of multiple offenses. The court may require the offender to serve a prison term consecutively if the court finds the consecutive sentence is necessary to protect the public from future crime or to punish the offender, and the consecutive sentences are not disproportionate to the seriousness of the offender's conduct and the danger the offender poses to the public. And then it goes on to say under subsection CB, the court finds in this case that at least 2 of the multiple offenses were committed as part of one or more criminal pattern of criminal conduct, and the harm caused by 2 or more of these offenses are so great or unusual that no single prison term for any offense committed as part of the course of conduct adequately reflects the seriousness of the offender's conduct. It cannot be underestimated the damage that you have caused to the citizens of Pike County, to law enforcement who every day get up, face the same sort of stresses that you do. They go home at night, they get up in the morning, their family, they don't know if they're going to come home. The sacrifices that these men and women make, I think you made a mockery of them. I could have imposed a much greater sentence than I have. As I said, I've taken into consideration some of the mitigating factors, but punishment is appropriate. To sentence you to, I consider the minimum. However, to sentence you to anything less than 3 years in prison would demean the seriousness of the offense and not adequately protect society from future criminal conduct by yourself and others. You have the right to appeal the court's judgment and sentence in this case, Mr. Reader. If you do not have the funds to file a notice of appeal, the court will provide those funds to you. If you cannot afford counsel to represent you on appeal, the court will provide counsel to you. If you cannot afford the documents or the transcript, the court also will provide that to you, and I will appoint an attorney if necessary to file a notice of appeal within 30 days. Mr. Bolger, have you talked to your client about whether or not you are going to represent him in the event of an appeal?
No, Your Honor, we have not. I didn't think that such a discussion would have been useful until sentencing
All
was
right.
pronounced.
If you are you need to notify the court immediately if you're going to stay on the case for purposes of the appeal. If he is indigent, as I said, the court will appoint an attorney, and I will furnish the transcript and the records if need be. In the event you do represent him for purposes of appeal, I would instruct you, Mr. Bolger, to file a notice of appeal within 30 days of this sentence. All right, does the state have anything else you want to add?
Nothing further from the state, Your
Does the
Honor.
defense have anything you want to add?
Your Honor, in our last telephone conference, there was some discussion of the situation that Sheriff Charles Reeder's father is in. There does seem to be a confirmation of the representations that I made in the telephone conference concerning the severity of his condition. Would the court consider giving us a report date?
All right, he pled guilty on, when was it, last year?
September 20th, I believe, Your
September
Honor.
20th, yes, all right. I have thought about this. If your father was on life support and some doctor, and I mentioned this, if some doctor had written a note saying that he was on death's doorstep, so to speak, I might consider that. But that's not the situation. And as I said, every action in life has a reaction. And it's normally the family of the defendant who suffers the most. Under Ohio law, a warden in a prison has the ability to grant a furlough under certain circumstances. If those circumstances should arise in the future, then you can notify the warden of the institution you're in, and at that point in time, he or she can consider the subject of furlough. All right. That concludes these proceedings.
I think they're in custody, but she didn't say that. Strong argument is that the two evidence charges should merge. But she ran them concurrent, so time service in 3 years. That's what she's getting, 3 years. Now, I'm not saying you can't take an appeal, but a strong issue, I'll mull it over in about 30 days before you have to file a notice. But the strong position is she's taken away by running the two tamperings concurrent with each other. It's meaningless, even though she may be wrong. It's still looking at a 2-year sentence on one of them.
No.
true.